Welcome, everybody. I'm Simon MacDonald. I'm the Master of Christ, and this is the 12th Christ College Kennel Climate and Sustainability Seminar. You may have spotted that we have technology around us. Somewhat unusually, somewhat even more embarrassingly, it is better than usual because we have joining us online Charlie and Ellen Kennel, and they are the people responsible for this seminar, so we think they deserve pictures. So Charlie and Ellen, welcome through the ether. I can tell you that I met them last summer in San Diego, and I think one reason Charlie and Ellen love this place is that it is almost as lovely as San Diego. So welcome. This evening we have a departure from our format in previous years. We have 3 speakers, so they're each going to go one after another. So after my introduction, Emma is going to go first, and then Helen and Laura will follow. We're very alphabetical order here. And when they've all 3 spoken, I shall ask a first set of questions. I confess they have had notice for these questions, so they may be especially fluent at the beginning. And then we will turn it over to the audience. But first, introductions. Emma Lees, who is sitting immediately to my left, is Professor of Environment and Property Law here at the University of Cambridge. She is a Fellow of Downing College, and she specializes in biodiversity protection in the European Union. Next to her is Helen Dancer, Associate Professor in Law and Anthropology at the University of Sussex. She works on rights and relationships between people and the earth, particularly land rights and the protection of forests. And last is Laura Clark. Laura and I both used to work for the Foreign Office. She should be especially grateful to me because I posted her to New Zealand some years ago. Anyway, now Laura is Chief Executive of Client Earth, which, quotes, uses the power of law to bring about systemic change that protects the earth for and with its inhabitants. Without further ado, I'm going to ask Emma to start.
Well, thank you, and thank you all for coming. I'm really looking forward to the discussion we're going to have. I'd also like to thank Rob and the CSAP team for organising it this evening. I think it's going to be a fantastic discussion. So my job is really to set the scene and to kind of establish where we are now and to get us thinking about why we might want to explore new legal avenues. I'm sure that the majority of you here today are already to some extent interested in biodiversity protection, because otherwise we probably wouldn't be here, except possibly my students who are here. They may be here for other reasons. But just to sort of start the picture, so biodiversity can mean diversity of lots of different things. It can mean diversity of ecosystems. It can mean diversity of species within those ecosystems. And it also means genetic diversity of individuals within those species. So it covers the grand scale and the micro scale. And it's a broad concept which encapsulates many different subtle problems. The goal of biodiversity protection law, or enhancement in law, is often to create or preserve the conditions within which those diverse ecosystems can flourish. And biodiversity protection is actually one of the oldest forms of environmental law. Indeed, although such laws may have been enacted with very different goals in mind, there has been law which supports biodiversity protection for thousands of years, albeit in different ways. So, to some extent, biodiversity protection is not a new legal problem. However, the traditional techniques that we have historically been using, which is enclave protection or area protection on the one hand, and protections for specific species on the other, are not very well equipped to deal with the complexity of modern biodiversity loss. And we know that because biodiversity depletion has not only continued, but has accelerated, notwithstanding the longevity of many pieces of law that are designed precisely to avoid that. Even within those systems with very robust environmental law on paper, this conservation and enclave species approach has not had the effect of slowing down depletions in our ecosystems. And there are a few different reasons for this. First, clearly, enclave protections, in particular area-based protections, have got boundaries around them. And equally clearly, the species that are trying to be protected within those spaces do not respect the boundaries. Second, to date, a lot of these protections have been conservation focused. That is to say, they are about preservation, not making things worse to prevent further harm. But that means they're not necessarily well designed to enhance or improve and to generate new connectivities between existing protective spaces. Thirdly, they have to an extent been designed for the wrong, or at least not entirely the right, reasons. So very historically, areas were protected as hunting forests, or as areas of beauty and inspiration for artists and poets, or for areas of wealth preservation. These are not necessarily bad things, but they're not the same thing as enhancing biodiversity. And that means that things have been missed or underestimated or undervalued in our law to date. And that generates a vicious cycle. Those areas that are rich in what was historically valued have been maintained, and those areas that have been underestimated have been allowed to degrade further. And finally, enforcement of that law is often underfunded or underprioritized, or just really difficult to do because measurement of biodiversity loss is hard and complex. So now we're looking for new tools which go beyond preservation of existing protective sites and which reach their fingers into the uses of land and water to promote connectivity within and between ecosystems. But these new tools will come with political costs. They can pose problems for housing, for agriculture, and most particularly also for the green energy transition. So even our environmental goals can potentially be sitting in tension with one another. They're difficult to implement and their successes can be challenging to measure. But we know that these tools are very needed. Not only is a biodiversity loss a problem in itself, it's also a problem for food security, for human health, and it undermines our ability to adapt to a climate future. So in short, and before I hand you over to Helen, we are in a moment where legal innovation is needed and where policymakers are developing and testing such tools. And tonight, we're going to explore what some of those tools might look like. And for the much harder part of solving the problem, I hand you to Helen.
But first, now, before Helen speaks, I'm aware that the duty of any decent chair is to mention the books, particularly the titles of the books. So Helen is going to introduce her recent book, touching on the idea of earth law and why we choose to reimagine judgments about earth law. Over to you, Helen.
Thank you very much. It's a pleasure to be here. Thank you so much for the invitation. The book that you see here, I'm proud to say, is available open access online. Anyone can download it for free. If you're interested in a hard copy, there are flyers outside for a discount. Why this book was written is to respond to the points that Emma was making about the failure of law, but also I want to add something else. The need for a fundamental shift in our values, the way those values are reflected in existing environmental law and policy frameworks, which don't address adequately and in many cases facilitate overconsumption of the planet's resources as well as inequality. So Earth system scientists and other Earth lawyers and theorists argue that humans in their most powerful position as Earth's dominant species do have the capacity to govern and regulate to ensure a habitable planet. It's possible, but we've not yet attuned our systems of law to achieving this. So the argument that I, together with my co-editors, Bonnie Holligan and Helena Howe, make in this book is that we need systems and approaches to law and governance that can meet the challenge of the planetary crisis and that can address the uncertainties we face, intergenerational equity, and repair the harms that humans have already done to the Earth. So Earth Law is an attempt to think about how we could transform our systems to meet that challenge. This is a book about legal possibilities. It's a vision for the future, and it's the culmination of 4 years of collaborative work between 22 legal scholars, as well as artists and young people who were involved in this book. And we were inspired by places around the UK, human relationships with land, with water, with the air, with other beings, and also our relationships with the past, the present, and the future. So in reimagining law for the earth, we drew inspiration from legal developments and social movements that were happening both here in the UK and around the world. So what exactly is earth law? Well, it's a very loose term. Let me say that first of all, because this is an emerging field of theories and legal innovations that are still taking shape. What the various approaches share, however, is an emphasis on interdependence, interconnectedness, and relationality between people and other beings, species, places, ecosystems. We don't separate humans and nature, we're part of it. So in fact, globally, Earth law has been evolving rapidly over the last 15 years, and particularly during the lifetime of this book. So I just want to highlight some examples from the UK and beyond. We do have Earth law in the UK at the moment. The Welsh Assembly in 2015 passed the world's first Wellbeing of Future Generations Act. And this act reflected public concern in Wales to solve long-term challenges by meeting the needs of present generations without compromising the ability of future generations to meet their needs. Rights of nature is another Earth law concept, and it's been used particularly to protect rivers and forests in various different countries around the world. Ecuador was the first country in the world to enshrine the rights of nature in its constitution in 2008, but there are many examples of rights of nature laws being implemented in countries as diverse as the United States, Bolivia, New Zealand, Bangladesh, Canada, Spain, to name a few. The human right to a clean and healthy environment is now recognised in the laws of more than 80% of UN member states. It's now recognised as a universal human right, but it's not recognised as a human right in the UK. There's growing global recognition of the importance of indigenous people's rights and how their knowledges are important in state laws, constitutions, and case law, such as the Inter-American Court of Human Rights. We now have greater insight into multi-species relationships, so the interests of farm and companion animals, as well as the impact that intensive agriculture has on our fishing, on our marine life, the impact of zoonotic disease on human health. And these insights are very important for advancing ethical debates and case law on farming and the treatment of animals. And the final example of Earth law that I want to highlight is the crime of ecocide, which enables prosecution of the most serious environmental crimes. And that's something that's being proposed for the International Criminal Court and has recently been incorporated as a European Council directive. So things are happening around the world, and particularly young people, bringing a wave of human rights-based climate change cases against governments, people of all generations, actually. Just to come to the second point about why we chose to reimagine judgments using Earth law, we were inspired by what's become a bit of a tradition in legal scholarship of reimagining judgments that have already been decided as a way of pointing out the fact that law is not as objective as judges like to think, like to pretend it is, and to show what's possible by creating a comparison with the original judgment. So the first example of this was a feminist judgments project that happened 18 years ago when judgments were rewritten using a feminist lens. And this is an example of that approach, but using these different earth law approaches to rewrite laws. And I'll talk about some of the cases that we use later. I just want to end with a quote from Lady Hale, who was the first woman Supreme Court judge in the UK. And she was a supporter of the English Feminist Judgments Project. And she said, "The business of judging, especially in the hard cases, often involves the choice between different conclusions, any of which it may be possible to reach by respectable legal reasoning. The choice made is likely to be motivated at a far deeper level by the judge's own approach to the law, to the problem under discussion, and to ideas of what makes a just result." So once we recognise that judicial decisions are informed not only by legal reasoning, but by other knowledges and motivations, we can see why it's important to recognise that firstly, that exists, and secondly, what are the implications for making claims and judging cases using different normative frameworks. We need to think about who is making legal claims, whose voices are heard, and who decides cases. So we wanted to apply that approach to reimagining law as earth law for the UK.
Thank you. And last of this opening round, Laura will speak about the work of Client Earth and its pragmatic approach to using the law.
Lovely. Thank you, Simon. And thank you very much, Rob, for kudos to you for curating this, this panel. And thank you, Emma and Helen. I think we're faced here with some inescapable facts and imperatives. The facts are the critical importance of biodiversity, how we as people are nothing without thriving biodiversity, but also the crisis that we find ourselves in terms of biodiversity loss and nature degradation, and the fact that existing legal frameworks have not done the job that we might have hoped they would do. And the imperative then for a conceptual shift in terms of how we think about nature, how we acknowledge and understand deeply that we are in and of nature ourselves. And then what follows from that, that we need to be moving to a point where we're making decisions that properly acknowledge our interconnectedness and our interdependence with nature. Now, Simon said how he very kindly sent me to New Zealand, which, you know, in response to a bit of lobbying, has to be said. And I had 4.5 wonderful years in New Zealand, and I made it my mission there to really strengthen the UK's relationship with Te Ao Māori, with the indigenous Māori of New Zealand, and really understand. I learned the language. I really, you know, did a lot to understand Te Ao Māori, the Māori worldview. And there's a huge amount that we can all learn from that sort of indigenous approach to nature. So, for example, in the Māori worldview, the mountain is an ancestor. She's a relative. And it's very much this sense of them being in and of te taio, of nature. They have this concept of kaitiakitanga, which is guardianship, how, you know, nature is not about resources to be used, it is for you to sustain and preserve for future generations. And there is in Māori habits, I think, called a rahui, which is about how you will stop taking, for example, you'll stop fishing for a while for reasons of conservation and preservation. So it's just, you know, for me, a sort of little insight into different conceptual ways of valuing nature, thinking about nature. So I'm going to talk very briefly, I hope, in 3 parts. First of all, I'll explain what we do at Client Earth and talk about what we have done within existing legal frameworks to protect nature. I'll then talk about what we are doing to try and help evolve the legal landscape in the way that is needed, and then perhaps explore a bit what we can do collectively to change mindsets, behaviours, and approaches. So what is Client Earth? Well, it does what it says on the tin. The earth is our client. We use the law to defend the earth and the people that live there. We are 300 people globally with lawyers expert in multiple different jurisdictions and different types of law: corporate law, financial law, administrative, human rights. And we're driving at systemic change. And how do we power our economies? How do we produce food and engage with nature? And then, more conceptually, this point about how do we get to a point where those who are making decisions, those who are in positions of power, whether in government, in business, making investment decisions, how do they put environment and future generations front and center in those decisions? So it's not just about the short-term return on investment or the election that's around the corner. So what does that mean in practice? Well, we litigate, we sue corporates and governments to protect the earth and its people, hold governments and corporates to account, and really set precedent. We work to strengthen the law, advocating for new legislation, regulatory frameworks, so that you change the rules of the road. And we also build the field. So we train judges and lawyers and prosecutors, and we work with local communities and indigenous peoples to support inclusive decision-making and ensure that more and more people are using the law to defend the environment and uphold their rights. So just a couple of examples of real-world examples of where we've used existing legal frameworks. We've enforced existing laws to protect the environment. So marine protected areas, it is hard to compute, but there are lots of countries that still allow bottom trawling in marine protected areas. So we've been litigating, we've got cases against Spain, France, the Netherlands, to really say this is absolutely not acceptable. And in fact, very recently, Denmark and Sweden have announced that they're going to legislate to prevent bottom trawling in marine protected areas. Wetlands are crucial for wildlife and for climate balance. We won a case last year. We brought a case against plans in Portugal for a new airport on the Tagus estuary, which is a critical wetland and place for migratory birds. We've worked to protect forests. In 2017, the Polish government wanted to log the ancient Białowieża forest, and we mobilized society, artists, politicians, even UNESCO to oppose the destruction. And eventually it went all the way to the European Court of Justice, which gave a landmark ruling, not just safeguarding the Białowieża forest, but also setting higher legal standards for forest protection across the EU. And we've also worked to protect the wild rivers of Europe, including safeguarding the Western Balkans' wildest rivers, working with local lawyers, training judges, but also litigating to stop damaging hydropower plants. But as well as that, as well as working within the system, we need to evolve and strengthen the legal landscape. So we're working, for example, to ensure that the global biodiversity framework in its national application really has the legal teeth needed, that new EU instruments like the EU Nature Restoration Law and the EU Deforestation Regulation bring the right policies and frameworks for example, industrial agriculture, which is one of the greatest drivers of biodiversity loss. And there's also a lot to be done in terms of environmental justice and inclusive decision-making. So we work very closely with local community groups in Indonesia and in West and Central Africa, supporting them as they engage on forest governance, forest protection, and conservation and sustainable forest management. We're also working in Liberia to develop the right legal frameworks needed for carbon markets to protect against carbon cowboys and protect indigenous people's rights to a healthy environment and use of forest resources. And my final segment then is how we can help collectively to change mindsets. How do we nurture a change of mindset to recognize that interconnectedness and that interdependence with nature? And how do we keep the rights of future generations front and center? So for us at Client Earth and others in the movement, that means deploying human rights angles and litigation, including focus on, for example, the right to a healthy environment. So that might be the impact of biodiversity loss on human rights. It might be the impact of industrial animal husbandry, of pig or chicken farming on the environment and, by extension, on human health and human rights. There are also, when you look at the wider landscape, really interesting evolving models of corporate governance. So, for example, steward ownership that prioritizes a company's long-term purpose over short-term profit, or integrating nature and future generations into governance. So 2 UK companies, House of Hackney and Faith in Nature, have recently put nature on their board, supported by Lawyers for Nature. So that's someone who sits on a board and advocates constantly for the rights of nature in all decisions that are being made. And at Client Earth, we're thinking about how we can embed Earth governance into our work. Now, our mission is already protecting the Earth, but what would it look like to explicitly have Earth represented on our board and through our governance, to think about the long and the short term and consider the nexus between climate, nature, and society. And finally, there are some models, for example, Earth Percent, which is set up by Brian Eno, which encourages everyone in the music industry to give 1% of any project that they do to Earth-related causes. So there are all sorts of different ways of evolving corporate governance models. So as we shift into the what could be, we're thinking about all these things and including what would be a model in terms of corporate governance that incorporates nature into board governance and into the wiring of any company, that be reporting, KPIs, salaries, and so on. So I'll stop there, but just to end by saying there are so many things that we need to do and so many different tools that can be applied, but I do think law is a really important strategy for moving beyond the political polarization that we're in right now, beyond the short-term thinking, and to that longer-term focus on intergenerational justice and getting to a point where we are living in balance with nature. Thank you.
Thank you very much, Laura. Thank you, Emma, Helen, and Laura. So now we have 2 rounds of questions. The first, if I may say, is underarm bowling. So this is what you're kind of expecting. So you can say all the things that you really wanted to say, but you only had 5 minutes. But then I'm going to have a second round where it's a bit more of a googly. So watch it. First, though, Emma, what legal tools exist already to overcome enforcement and implementation problems?
See, I've given myself a difficult question because the answer is not very many, by which I mean this. The enacting law is not doing anything, right? Having a new legal framework in place doesn't mean that the things that you've put into that law are necessarily going to happen, because law is the first step in generating a change, but it's not the end of the picture. So we have lots of environmental law. I already mentioned some of it. Some of the newer stuff is already building a slightly different approach to focus on the connectivity between ecosystems in particular. But unless that is followed through with a genuine intention to carry out the obligations that are stated in that law, they won't do anything. So the tool to overcome an implementation gap is not a legal one, but I think an intention one. If you approach the law that you have wholeheartedly with the intention of complying with it, rather than trying to get away with just about not complying with it, that will produce a bigger change than layering more law on top of what already exists would do. So my legal tool to change the law is to change the attitude of the people to that law.
Thank you. Helen, how did you develop and use Earth law in your book? And could you give us some examples of how contributors did this?
Yes, thank you. Well, we didn't start with law. We started with people and place. And we really wanted to ground this in the UK and to see what Earth law would look like in the UK. So we thought about different locations, different themes and issues around the UK that would be important to explore through law. So, for example, ancient woodlands, post-industrial mining landscapes, polluted rivers, wind farms in Scotland, cultural landscapes of the Lake District and Stonehenge, the idea of a good farmer. These are all themes that come up in the book, and also how British interests abroad affect people and environment in other countries. So we looked at examples of oil pollution in Africa caused by British companies as well. And so each of the authors, they had a choice. We didn't prescribe what particular lens or legal tool they should use. We wanted diversity of approaches in this book because this is a very contested space. So the overarching theme was how relationships between people, place, and the more than human world can be produced, transformed, and destroyed through law. And we invited the contributors to take an earth law lens of their choosing for reimagining their judgment. So each judgment in each chapter of the book contains a reimagined judgment introduced by the judgment writer, and a commentary written by another academic providing an alternative perspective on the judgment that's been written. In some cases, the reimagined judgment was done in such a subtle way that it could have actually been decided that way by a court hearing that case at the time. It was more of a mindset shift than any kind of legal shift. Other cases were more speculative. They required entirely new legislation that doesn't currently exist or exists in other jurisdictions but not the UK. And some judgments engaged in time travel to imagine a case in the past being decided differently now based on changing norms. So yeah, different ways in which people interpreted the cases. To give an example, so my own judgment was the case that Chris Packham, I'm sure many of you have heard of Chris Packham, environmental campaigner, broadcaster, brought against Boris Johnson and HS2 and Grant Shapps to try and stop the destruction of ancient woodlands along the rail line of HS2. And I decided to reimagine that case through the lens of the well-being of future generations, which exists in Welsh law but not in English or UK law. And I decided to take inspiration from family law, actually, because I used to practice as a barrister in child law before I became an academic. And there was a judgment that I was really inspired by, a case that involved a 14-year-old boy, and there was a dispute as to whether he should live with his mother or his father, who were separated. And Justice Peter Jackson, in that case, wrote the judgment not in the conventional way, but as a letter to that 14-year-old boy, explaining in terms that the 14-year-old boy could understand why he'd reached the decision that he'd come to. And I thought that was such a powerful way of writing a judgment, and it had so much integrity to it, because you can't hide behind legalese if you're speaking directly to a 14-year-old boy about his own future. So I adopted that same approach in my judgment, and I decided to make it a dissenting judgment written as a letter to future generations, explaining why I disagreed with the decision of the majority of the judges in that court who had allowed the destruction of ancient woodlands to go ahead. And for the commentary for that judgment, I didn't, that actually wasn't a legal academic. I actually gave the judgment to two 14-year-olds who I didn't know at all. They were volunteers through a charity, I should emphasise that. But they read the judgment, and we had a conversation about it, and their words are the commentary to that judgment. So it was good to have young voices in a law book. You don't see that very often. So that was one example, and another example was ecocide. So that's a crime that doesn't currently exist on statute books in the International Criminal Court. But Rachel Killeen imagined a version of the crime of ecocide to prosecute a certain British company for, or I should say, an individual director of a certain British company for the crime of ecocide for pollution that has happened in the Niger Delta. So those are just some examples. Sorry, I've gone on too long, haven't I?
You've gone on long enough to get a round of applause. Thanks, Helen. Laura, Client Earth is a pragmatic, practical organisation. We have a lot of people in the audience who care. So can you say something about what individuals can do? Because in the end, we want, as individuals, to help. Yeah.
And I think this is interesting because often you get this kind of polarized debate between people saying, oh, well, you know, the focus on individual carbon footprints, right? And I don't know how many people here know that the idea of an individual carbon footprint was actually invented by the big oil companies to divert attention away from what they were doing and say, well, actually, it's all about the individual decision to drive a petrol car, to fly, and so on. Now, the impact of that, of course, is it makes people, particularly young people, I think, feel hopeless and helpless because they know that their individual decisions actually don't make the difference. What makes the difference are these big systemic issues. But I don't think it's enough to say, oh, well, therefore, the individual can't do anything. And it's all about the systemic change that we need to see from governments and corporates and frameworks and things like that. I think the answer is individuals, yes, actually, those decisions about how much you fly matter, but individuals can actually play a part in the systemic change needed. So that's everything from where you put your money, who do you bank with? Is your bank invested in fossil fuel and new fossil fuel infrastructure? Where is your pension? Is your pension sustainable? You know, how you vote, how you engage as a citizen with your mayor or with your MP, and so on. And also how you can, what causes you can support. Are there particular activists that you want to support or NGOs that you can support? How can, you know, and what pressure can people as employees bring to bear on their employer or on a university or in a school? There's so much that can be done to shift the attitudes across the board because judges, politicians are all part of society and that is constantly evolving. And I think individuals can play a part both in that systemic change but changing societal attitudes and expectations.
Can I ask, does Client Earth signpost people? You said, you know, your choice of bank. Now, there's lots of prejudice about banks, but I don't know which is good and which is less good.
So you can do, I mean, I probably shouldn't be in here sort of saying you must all go and bank with, you know, X or Y bank, but it's quite a quick Google will tell you what are the worst banks. There have been various reports done, one called, I think, Banking on Chaos, looking at all the different banks and what their level of investment is in fossil fuels and what the best ones are that are not invested at all in fossil fuels. And it's a really simple, it's always very easy to switch your banking, and it's a very simple thing that everyone can do. And if you're interested, Make My Money Matter have got a really lovely campaign. This is run by the director of all those rom-coms, you know, Love Actually, what's he called? Richard Curtis. Yeah. He's behind this organization called Make My Money Matter, which highlights the you know, how much of the banking and pensions industry is invested in fossil fuels. So they have people like Benedict Cumberbatch doing cameos and Olivia Colman, all, you know, sort of really highlighting what is happening when, you know, you think you're just getting banking services, but actually you're inadvertently funding fossil fuel expansion. And one of the most shocking things, I think, and this is a particular problem in the United States, is big insurance companies that are at one time saying to individuals, I'm sorry, we can't insure you anymore because your house is at risk of wildfires or it's at risk of floods, we can't insure you. At the same time, their investment funds are investing massively in new fossil fuel infrastructure. So they're basically fanning the fires that then mean that they are not going to provide insurance for vulnerable families.
Thank you very much. So that's the easy bit. I had a boss who would have described what's happened so far as a feast of reason and flow of soul, because basically everyone is violently agreeing with each other. And, you know, and this exists in this very friendly, receptive auditorium. And I think that, I mean, that's fine and may have been enough until the 5th of November 2024. And then we had a new sheriff, I think he likes to call himself, elected. Or king, yes, is his latest self-description. And for the period of transition, people wondered how bad it would be. Was he really serious about what he'd suggested in the campaign? And then on the 20th of January, exactly 1 month ago, he became president. And Donald Trump, it seems to me, is with every atom in his being hostile to everything that has been said so far. So my question to all three of you is about resistance and challenge and how to keep this going through at least 4 years of the single most powerful government in the world believing drill, baby, drill is an responsible environment policy. First, Emma.
Okay. So, well, I'm a lawyer, so I have to have some faith in legal systems. And
you are aware about how many Supreme Court justices he's appointed so far?
Yes, so that's what. So I have some faith in legal systems. I suppose how to keep it going in the light of that is to recognise what I said at the beginning, which is biodiversity preservation happens on grand scales and it happens on micro scales. And the micro scales accumulate. So even if you have some areas where there is grand scale destruction, maintaining micro scale preservation is the only technique which can counter that. So I would say even if you have grand scale destruction, jurisdictions that aren't hell-bent on digging baby dig, then maybe those can accumulate to act as a counterbalance. The EU has recently introduced what on its face is a very ambitious biodiversity preservation law. I say on its face because I'm not sure, firstly, that member states have fully understood quite how ambitious it is in its enacted form. And secondly, I know they haven't got their heads around how they're going to do it. But if they do manage to get their heads around how they're going to do it, and again, implement that wholeheartedly and with a true intention to achieve the goals that it establishes, those tools exist to have that micro accumulate to a very large scale. Wholehearted and very potentially very effective preservation and enhancement effort. So, yes, work together, try.
So, okay, some hope.
Sure, yeah.
Okay, Helen, can you build on that or take it apart?
I think I will build on it, actually. So I think the strategy that we've seen is fairly obvious and crude, which is to overwhelm and confuse so that we're left like bunnies in headlights. And the response to that is to focus and not be overwhelmed and to pick your battles and each of us to decide what matters to us, what's within our control, what can we do, but also to work collaboratively. And I think when I think about law, I always think about power. The two are so intimately connected. And power does not exist in one space. Donald Trump, much as he likes to think of himself as world king, is not at the apex of power. Power is everywhere. Power exists in networks, and that gives us the opportunity always to exercise the power that we have. And I think, in a way, I'm optimistic, actually, because sometimes you can be complacent when you've got someone sort of inspirational and good in charge, and you think, oh, right, yes, let's let sort of, they can get on with it then. But we don't have that luxury. So in a way, I'm actually more optimistic that we might actually get things done in response to the horror of what's happening. Not that I'm saying any of it's good, but... and I think where this can happen most meaningfully is in communities, which I think echoes your point, Emma. And I think that's always where reality lies, actually, in communities, whether those are geographical communities or communities of people interested in different things. That's where the real world exists. And that's where change can still happen despite what's happening at this sort of global and national level. So I refuse to be pessimistic.
Very good. Announcing your candidacy as a prospective parliamentary candidate.
No, definitely not.
And Laura.
So I'll build on that because I agree with lots of that. I think because of course we're not just talking about the States. The States is the most egregious example of it, but actually across Europe we're seeing increasing polarization, the rise of the far right, and this alignment of these far right parties that are anti-immigration and also anti-net zero, which of course, if you pause even for a moment to think about it, makes no logical sense at all, because if you do nothing to tackle terrible climate change, you're going to get massive flows of climate refugees. But leaving the logic aside, that's what we've got. And you've got an attempt to say that if you are focused on climate action, you are of necessity on the left, you're progressive, and therefore, there's this attempt to really lean into that polarization and make the climate and environment agenda a partisan agenda, which of course it isn't. So I suppose my question is, how do we resist that polarization? And that sense that environmental protection, climate action is only the domain of the sort of liberal elites on the left. How do you really build agency and build consensus across society? And where I come back to is, it's not political to want to be able to breathe clean air. It's not political to want your water to be clean. It's not political to want your children to live in a safe and stable climate. And so how do we make the arguments in the right way? We had a fascinating meeting this morning where I learned that only 10% of people in the UK, are what's called climate progressives. So they start with climate action is necessary in and of itself. So you've got to come at other angles. What is the angle in terms of energy security or energy sovereignty, for example, to protect us against Putin? Or also, how do you build agency, by which I mean the number of people who feel like they are getting their arms around the issues themselves. They're not having some transition done to them, but they're getting engaged, whether that's the community groups that we work with on clean air cases across Europe, people whose children are suffering from asthma or even dying from air pollution, or whether it's a case that we're bringing in Colorado, a class action, which is with Colorado landowners, challenging the big oil companies who essentially effect a fraud in that they sell, when they own a big oil well, for example, they get all the profit from it, but towards the end of its life, they sell this oil well onto a shell company that goes bust just at the point when that oil well should be plugged and made safe. So there are 2.1 million oil wells across the US that are unplugged and leaking methane. So we're bringing this case with Colorado landowners to say this, to shift the accountability. So it's how do you not make this legal action the preserve of the elites, but make it the preserve of citizens who are trying to effect change for their own interests and the interests of their communities.
Can I ask, Laura, what's your take on China, the other great polluter? Is citizen pressure making a difference to Beijing's policies?
So it is. So we've been in China since 2017 as Client Earth, and we originally went in there to train judges in environmental law. We've now been supporting the development of public interest environmental litigation and putting advice in on things like Greening the Belt and Road Initiative. I think the fascinating thing there is there is citizen pressure, right? When you sort of think about the air pollution that there was in Beijing and the water pollution. I went there last June. The air is so much better. The rivers are cleaned up, and that's partly because the government needs to be providing these goods for its people, these goods of clean water, clean air, and it's not enough to have the right laws and frameworks in place. Even in a non-democracy, you need to make sure that those are being enforced and upheld, and that means you need judges that know how to hear these sorts of cases, and we work with the rather grandly named Supreme People's Procuratorate, who are basically, we don't litigate at all ourselves, but we've been supporting them in bringing public interest environmental litigation to advance some of these goals.
Thank you, Laura. I think this also deserves a round of applause. Because we're transitioning to you. Now, already we have the first hand, so I know there are questions. There is a microphone, 2 microphones that will be passed around the crowd. And I'd like to know at least 2 questions together so that we have as little pause between questions as possible. So the first one is the man with a beard and a white T-shirt here. And the second is the man with white hair there. You'll notice I've used the word man twice. When I'm looking for 3 and 4, on the front row and that row. So you see the man gets the first go. I've promised him his go. Not that man, the man behind. This was an attempt to be quick.
With the red tie.
Can the man with the white T-shirt ask the first question, please?
Can you hear me?
Yeah.
Fantastic. My name is Ben. I'm on the environmental policy course, and Emma is one of my professors. So interesting to hear that. My question was mainly to Laura about obviously you've got a huge range of projects that you're working on, from training judges, litigation, and working with communities. I guess what has been most effective in the past, and then what do you think is going to be most effective in the future, given this huge shock that we've just faced on the political landscape and the increasing uncertainty globally? Thank you.
Thank you.
Yes. Second question, please.
Yes, I've got the microphone. I think I'm the man with white hair. There seems to be a lot of us in here, actually. I'm going to make myself a bit unpopular because I don't agree with many of the core propositions that the panel set out initially. And just actually on personal carbon footprints, which you describe as being the product of sinister corporations. Karl Marx didn't know anything about carbon footprints, but he was very clear that consumption drives production and that energy giants will be responding to the demand for their products to fund out to have all the lifestyles that we enjoy. But I just 2 related questions, if I may. I heard quite a bit about human rights, but there are competing human rights. There are things like freedom of movement and the right to gainful employment and so forth. And governments have to manage these competing interests when they are taking decisions. They have to think about productivity and prosperity and economic growth and job creation, whereas your propositions prioritise over everything else, it would appear, environmental protection, preventing biodiversity loss and so forth. And by doing that, the hands of governments are tied so that they are unable to necessarily respond creatively or dynamically.
Can I remind you, you're asking a question?
So
the
question,
small reminder.
So I beg your pardon. So the question really is, how do, are you not in danger of preventing governments from responding dynamically to changing circumstances and to take difficult strategic decisions? And my second very brief question is, there are losers as well as gainers from what you're saying, the fisheries workers, the forestry logging workers and so forth. How do you compensate them for the loss of their livelihood through your propositions?
Okay, we've had 2 people and many questions. I'm going to just go down the line and you can pick out. The great advantage of having so much material is you can pick and choose what you want to answer. So first, Emma.
Okay, so I will go with the human rights sit in tension with one another as a theme. Yes, they do. And speaking personally, I do not think a human rights approach is the right approach to solving the problem, but saying human rights is not the right solution doesn't dissolve the problem, if you see what I mean. So undoubtedly, if you take a rights approach, the problem with a human rights framing is that even within the conventions themselves, they are said to be equal. All rights are given to all people and all rights are equal, right? But of course, in practice, on every decision, certain rights will be prioritized or not. For those who advocate human rights in relation to the environment, what they are advocating for really is a wider pool of people who are given the task of holding the government to account for its own failures to make appropriate decisions. Human rights protections are, with the exception of torture, and are otherwise not absolute, right? They are limited by the needs of a democratic society, as long as those decisions have been made in a rational, reasoned, proportionate manner and in compliance with other law. So a human rights tool is not a silver bullet for saying you have a right to a healthy environment, therefore X, Y, or Z. What it does is change the conversation to say, including in our balancing on our scales, is the right to a healthy environment, which then sits with those other things. So for those who want to take a human rights framing approach, that is not to say it is an absolute right, because almost no human rights are. But the goal of those approaches is to widen the stakes and to turn what is potentially seen as a peripheral concern into something which is seen as being central to the ongoing existence and flourishing of the human race. So that's what I would say about the human rights framing and its potentials.
Okay, thank you. Helen?
In the interest of time, I think Emma summed that up so beautifully that for me to kind of add on to it would just mean that we'd have less time for other questions. Okay. So
there was nothing else in that smorgasbord that you wanted to.
Well, I was going to respond to the question about in danger of preventing governments from responding, and I think Emma's answered that beautifully. So
okay.
Yeah.
Laura.
Yeah. Yeah, agreed. So I'll just answer the question about the specific Client Earth question. I think in the past we've had real success in blocking, for example, big fossil fuel infrastructure. So we blocked a new coal plant in Poland as a shareholder, actually. We brought a case as a shareholder, and the coal plant, if it had been built, would have had the emissions equivalent to the annual emissions of New Zealand. And so we've also had lots of success with things like clean air cases, forcing governments, local authorities to improve standards there and properly enforce them. We're moving now to sort of thinking far more about how do you affect the systemic change. And for me, when I look, considering the environment externally, for me, the biggest area of promise is around corporate action, corporate accountability, and how do you integrate a risk-based approach to the decision-making, to board directors, for example, so that they are properly incorporating climate risk and biodiversity risk into their decision-making. So, for example, we brought a case against the board of directors of Shell, saying that they were not doing enough to manage climate risk, which is, I won't go into sort of the different elements of climate risk, and that case failed. But there will be a case quite soon in an important jurisdiction that finds directors of companies liable for not managing climate risk. And when that happens, when that articulation of fiduciary duty happens, that will be a real tipping point in terms of the behaviour of boards and directors and how companies are led and managed.
Okay, thank you. I hope to get in 4 more questions before we finish at 1:45. Question 3 is here, and question 4 on the front row.
Hi, I'm also doing the environmental policy course, the MPhil, and we have actually a national environmental law and an international environmental law module, and I'm very interested in the international law, biodiversity law, and everyone talked in the beginning about creating a new framework, different approaches we can take, kind of creating this new amazing system. And I guess my question is there anything you would keep from our existing frameworks? Is there any value in the way that we currently govern biodiversity, or in an ideal world, would you just throw it all out and build it all anew?
Okay, and on the front row?
Hi, I was very interested in what Laura said about corporate accountability, and I'm just wondering. So, in the context of the public-private finance model that's supposed to be our future at the moment, how can any ENGO or cash-strapped government body be impartial if cash has come their way? Basically, what I'm asking is, who decides what is well-being? You've got a recent report saying farmers in Andalusia say they're hosting Northern Europe's green transition. You've got rural communities in Wales saying they're hosting growth for the southeast with pylons, onshore wind, solar farms. Your comment about the Future Generations Act for Wales. Well, what is that well-being? Whose well-being?
I'm going to do it in reverse order this time. Laura can go first.
I'm going to let Emma answer the biodiversity question, I think. And I think I've understood your question. You're essentially saying money talks. Money does. Yeah, money does talk, and we're seeing very interesting developments, of course, in the US, where people are not allowed, investors are not allowed to do stewardship anymore. So, and even engaging with the companies that they're investing in to improve their behaviour on certain ESG elements, because of course ESG is now a taboo word there. As regards the ENGOs, I can speak for myself and many others in the movement. We have very rigorous screening. We will only take funding from we will never be led up in terms of our agenda by our funders, and so we have very clear strategy, and then we screen our donors very carefully, because of course the last thing you want to do is be an environmental organisation that's funded by fossil fuel organisations, for example.
Moving down the line.
Yes, I'd like to answer this question here. Thank you. I definitely wouldn't get rid of all current environmental law, because we need environmental regulation, and we need it better implemented, as Emma said. But I see earth law, if you want to call it that, as a kind of a family of normative approaches, so kind of moral lenses, if you like, that are capable of underpinning all areas of law, not just environmental law. And in that respect, I think it links to the question that this lady here asked about the Welsh Wellbeing of Future Generations Act, because that act was brought in following a public consultation in Wales called The Wales We Want. And that act originally started as the Sustainable Development Act, and it became the Wellbeing of Future Generations Act in response to that public consultation. And so it's drawing upon the kind of sustainable development principle of meeting the needs of present generations without compromising the ability of future generations to meet their needs. So it's not an either or, it's a both. What are the needs of present and future generations, and how can we make sure we're not borrowing from future generations through overconsumption today? So that act is for everyone. And it sets out a framework which underpins all areas of government decision-making in Wales, not just the environment. So that's why I say I think it's an example of what we might call earth law. because it's a change in mindset that influences decision-making, whether it's in health, education, environment, whatever. And so that, I think, is what to respond to your question, is what Earth law as a family of theories is capable of doing. It's not a replacement for environmental law. Environmental law is still very much needed. And we have examples of a kind of Earth law approach already in environmental law. For example, the precautionary principle, which is the idea that we shouldn't take risks that might cause environmental harm in the future. We need to be cautious about the risks that we're taking. Another example is the Sanford principle for national parks, which is the idea that the conservation of national parks should override recreational priorities, where the two conflict. So I think these are examples that we already have in environmental law, which are good as a way of thinking about our interactions with the environment in a way which is sensitive. So I definitely wouldn't want to be throwing away the good laws that we already have.
And Emma.
By contrast, I think I probably would. So there's loads of great stuff in environmental law. Of course there is. There are a lot of problems with it. Like, firstly, it is just so messy. It is so difficult to work through it, right? I've spent a certain number of years attempting to do that, and it gets a bit easier, but it's still very challenging to work out precisely what law pertains to any particular question, because it's so layered and there's so many different things just kind of heaped on top of each other. Not that simple law necessarily is better law, but certainly attempting to rationalise some of it may be a good starting point. I also would scrap what I think is a fundamental assumption built into a lot of biodiversity protection law at the moment, which is you pick what you protect. And you pick it for scientific reasons or whatever reasons, but you get a big map and you go, this bit, that bit, this bit, not, and the global target 30% by 2030, all of this is the mindset of, let's get out a big chart and pick what we're going to try and save, right? And the rest of it, right. So I would probably attempt to move away from the mindset of you pick what you protect and you abandon the rest. That would probably be the thing that I would scrap. The thing that I would keep, which is very unglamorous, is that a lot of the law at the moment has got monitoring obligations within it, which are not very wholeheartedly followed through. But without the information, it is almost impossible to make any meaningful decisions. So I would say that the monitoring obligations which are in there, which are hidden and which are not splashy, should be the ones that we really keep and push to maintain as being the source of sensible decision-making through the collection of information.
Now, the fifth question is from the person in the audience who is most obviously a parent towards the back. And the sixth and last question is the lady with the sort of red scarf in the middle. So, father first.
Hello, thank you. I'm Jakub Kronenberg. We are from Poland, a country that was mentioned here a couple of times. And I'm a visiting scholar here working on different narratives used for bird conservation. And I'm wondering, you mentioned relationality, you mentioned even multi-species justice, and I'm wondering about the agency and the representatives of nature, like the ability to represent itself. If we are talking about the rights of nature, this is a question that emerges beyond just having legal guardians. And how, if we were to actually acknowledge the rights of nature, how would the system change if nature were to be represented on its own?
Final question.
Hi, first of all, thank you so much for this amazing lecture. I'm just absorbing the amount of information that I have received. I'm a student of public policy. I'm doing my MPhil at Police Department. I'm Taiba, by the way. I just wanted to ask, because I'm looking at it from a lens of a regulatory perspective, the EU's emissions trading system. Do you think the UK or the US could replicate it, and what are the chances of a developing country like Pakistan or India if they want to have a similar regulation? Because we have air pollution, and the extreme marks of it were crossed recently in Delhi and Lahore. It was not breathable, and if children were in Lahore, they were prohibited from entering because it was not safe for newborns at all. Thank you.
And Laura.
Howard, I'm really interested in what my fellow panelists say about this. I feel they're better qualified to address both questions. But how would the law evolve for rights of nature? I mean, we've already established, one of my first ever jobs, I worked in the Ministry of Justice on something called the Mental Capacity Act, which is how do you make decisions for people that don't have the mental capacity to make their own decisions, whether for whatever reason. And we've already got well established in law and society that corporations have legal personhood and people can go and speak to them and defend their rights. And of course, that's all underpinned by that property law and so on. And so, presumably you could get to a point, but this is where it comes to the societal attitudes, where you do get human advocates for nature in some aspects, and they have standing in some way in court. But it feels like that's something that we could aspire to, but it's a long way off. If you want to improve on that answer with your...
Yeah, I think the representation of nature is a really interesting question. Firstly, the concept of nature, I think, is such a loaded and difficult concept because there isn't a consensus on what nature actually means. Some people say it includes people, some people say we're apart from nature, which is the kind of Western philosophical history of the word. But when it comes to representing nature, whatever nature means, I think we need to be extremely careful. I think we need to practice humility and recognize that as a human species, we can never know. We don't have the access to the knowledge of how another species thinks and feels and would like to be represented, because it doesn't mean anything to them to be represented, because legal frameworks are an entirely human construct. So let's not kid ourselves that we can ever truly represent, an animal or a forest in that way. What I think we can do is gather scientific data, empathize, observe, and put together legal arguments that represent our best attempt at understanding what other species might need. But I think if we say that we speak for nature, we cross a line, and I don't think we should be crossing that line. So I'm not keen on the concept of, say, putting nature on the board, because I think that is an example of crossing that line of speaking for nature in a way that I don't think is possible to do. I am, however, very supportive of the idea of having the nature or the earth and what it needs as a kind of a moral touchstone, if you like, for organisations to set their priorities around. But I do think we need to be very careful about representation and practice that kind of what Lorraine Code describes as epistemic humility, being humble about the limits of our own human knowledge. Yeah.
Thank you very much. Now, when we finish, of course, you'll all have the chance to further quiz our panelists, but the last word in the formal session goes to Emma.
Okay, thank you. So on the representation point, one of my things that I say to myself a lot is who decides matters, right? And if you start from the perspective of the identity of the person who's making the decision is probably as important as the question that they are asking themselves. You would design decision-making processes perhaps somewhat more sensitively than they are at the moment, which are built around the question rather than the identity of the decision-maker. In terms of representation for nature, I don't have an answer to your question, but an example of where that particular question becomes embedded within a much wider political question, which is in the relation to the New Zealand example that's been mentioned. They're on the decision-making body about representation of rivers, which have been given legal personality in a certain sense, is a combination of representatives of the New Zealand government and of Maori communities. And those bodies have been set up in part as a way of also reconciling wider questions about the relationship between Maori communities and the New Zealand government, right? So the question, how do we represent the river, is also a question, how do we build a governance system which is inclusive, right? So whatever your take on it, let's not forget that the politics of the dynamics between groups that exist in general do not suddenly disappear when those groups are brought into the room to now represent a natural feature or something. All those dynamics will still be there, they'll just be about a different question. So that's one point on representation. In terms of carbon trading system, this is not my specialist area, so I don't have an answer to that either, except to say that I thought the framing of your question was interesting because you asked about carbon trading schemes and related that to air pollution. And this is, I think, something that gets a little bit forgotten when we talk about climate change and carbon emissions, that climate change and carbon emissions is a long-term, large-scale problem, and air pollution is its immediate, local outcome, right? So carbon emissions cause climate change and air pollution, right? So when we think about one, we're also thinking about the other one at the same time. And I think one of the consequences of a much brighter light being shone in respect of climate change is that air pollution will also be swept into that conversation as opposed to necessarily being treated as a separate environmental problem.
Thank you.